Hey out there, legal warriors. Would you be curious to know of a way to get a criminal case dismissed in Washington State just by agreeing to something with the alleged victim? Is it possible? Does that even make sense? Is it a good idea? Well, if you're interested in this area of the law, stay tuned because this is the video for you. My name is Attorney Lance Fryrear, and I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people will get the help they need. I'm just going to jump right into it. Is there a way that you can get a non-felony matter dismissed by, sort of agreeing to something with the alleged victim? Well, guess what? There is. And that's a statute in Washington State known as Compromise of a Misdemeanor. And that's, the statute is RCW 10.22.010. I remember it because I use it a lot over the last 20 plus years. And that statute basically says that if you're a criminal defendant in a non-felony case, that if the victim of the crime that you're accused of has a remedy at civil law, like for money damages, right? And if the victim appears in court and says they've been civilly satisfied for their damage, the court can dismiss the case. Wow. So what type of cases does that apply to? Well, the statute says it does not apply to domestic violence cases, and it does not apply, strangely, it says it doesn't apply to gang graffiti cases. I've not seen many of those, but so no domestic violence cases, no gang graffiti cases, nothing done riotlessly as part of a riot, and nothing that is a felony, right? So again, what are the requirements? One, the victim has to have a civil cause of action for damages. So let's start there. Well, what type of cases might that be? Well, a theft case, right? A theft case, a store and a shoplifting case has a civil cause of action for their enforcement costs. It's actually written right into Washington State law. And most courts see it that way. There's a few that don't. I'll protect the innocent here and not say which courts may not see it this way. But basically, if someone takes something from Nordstrom and Nordstrom wants $700 of enforcement costs, then that might be a case where if we can settle that claim that Nordstrom has with them, we may be able to use the Compromise of Misdemeanor statute. So that has to be a crime where the victim has a civil cause of action. That's not every crime, right? What's another crime? Well, possibly hit and run, right? In hit and run, there's probably been some property or vehicle damage caused by the defendant, probably, and they would be able to, the victim, probably sue for those damages. So that would be a possible case where we could use a compromise. And those are the two most common: theft in the third degree and hit and run attended and hit and run unattended. Are there some other areas? Well, technically, I think you could use one for criminal trespass, because people have a common law right to sue if there's trespass. It's harder to identify damages, right? And I definitely think on a non-domestic violence assault, there's absolutely a civil cause of action for any injury suffered, right, in the assault. Now, occasionally prosecutors push back on that. They don't like, buying your way out of that type of crime, is what some prosecutors might say. But I think certainly it applies, and we have used the compromise statute successfully in non-domestic violence cases. So, one, you have to have a civil cause of action. So let's say we've got one of those cases where we have a civil cause of action against us potentially. So now what? Well, two, we have to satisfy the alleged victim for their damages. So how do we do that? Well, it's going to be your attorney, most likely, working with whoever the victim is. In a store case, it's probably going to be working with a law firm that represents the store. There's several law firms in New York that represent, in other states, that represent all the sort of the major retailers, the Targets, the Fred Meyers, things like that in the world, the grocery stores, right? Some stores like Costco, there's a unique process that not many people know about, and other stores may not do anything, right? They may not offer anyone because they may not ask for money. But so your lawyer is going to work with either the lawyer representing the entity, or if it's a hit and run case, your lawyer's probably going to reach out to the other driver or the property owner to ask him, hey, do you have any damages that we can compensate you for, right? Was there something insurance didn't cover? Did you miss some work? Things like that. And so once the alleged victim says, yeah, there's some amount of money that I would agree to settle any civil causes against you for, then we've got to find a way to get them to satisfy their civil claim, right? Because they're not releasing criminal liability in this statute. They don't have the power to do that. Only the prosecutor can dismiss a case on their own motion, or this law says a judge can dismiss the case if the victim has been civilly satisfied. Okay, so they're not agreeing to dismiss the criminal case. That's not what the statute says. They are agreeing to settle their civil claim, and now the lawyer can present that proof to the court. So number 3, that statute says that if the victim appears in court and says they've been civilly satisfied. So 1, it has to be the right type of case. 2, we have to get the agreement and pay them. And 3, how do we show that the victim's been civilly satisfied? What does that appear in court language mean? Well, I don't think the appear in court language means the victim has to come to court, because that's not ever what happens. What we say that means, and what the court and the parties involved seem to agree that it means, is that means in writing, that they appear in court in writing. Just like a criminal defendant enters a notice of appearance, the lawyer does, right? We're appearing in writing. The alleged victim can appear in writing and state they've been civilly satisfied. So how do we do that? Well, when we settle the matter and pay the compensation to the victim, typically they are going to sign something, a civil release, saying that, hey, I release the defendant or this person from liability, and you can use this to court to prove that, right? So that's the hard part. Stores and stuff like that, sometimes the personnel, they don't want to sign these things, and they don't, and we're not meeting them face to face, right? We're not driving to New York for this from Washington State. If it's a different type of case, a hit and run or something, oftentimes your attorney is able to meet with the alleged victim right there and just sign this and take your money, okay? So then it's more clean. It's probably not something you want to try to do yourself, though, because it can get pretty hairy. You shouldn't probably be talking to victims in a case. That's something for your attorney to do. But so appearing in court, we think, means in writing. So finally, what's the 4th thing? Well, now your attorney's got to file a motion, right? It's got to file a motion that says, I hereby move to compromise a misdemeanor under RCW 1022-010. Here's the amount of damages, here's the proof of the satisfaction, and here's an order that dismisses the case. And we're also willing to pay any costs incurred by the court, because that's part of the statute, right? Some courts have a court cost they charge for the dismissal, $150, $250. Some courts do not, okay? But so your attorney needs to write the motion, needs to serve it on the prosecutor, and needs to give it to the court. And oftentimes it's handled at the pretrial hearing you may have coming up, and sometimes it's a separate motion, but it's generally better to handle it on the pretrial hearing so it doesn't, really stand out, okay? And so then the court does not have to dismiss your case, right? It says in the court's discretion. So the court's going to look at your criminal history. If you got 5 prior thefts or 3 hit and runs, well, they might not think you're an appropriate candidate to get a dismissal under this statute, where that gives the court the power to dismiss if we met all those other requirements, okay? But usually the case will get dismissed. I've had 1 in 20 years not get dismissed. Court shall remain nameless again. But we still handle that case well in the long run. But so usually if your lawyer's done things correctly and your record isn't too bad, and when we have a normal prosecutor involved, then everybody's happy, because basically the law says, hey, if the victim's happy and settles the matter with you financially, and it's not a very serious case, and you don't have that bad of a record, it's okay for the court to dismiss it, because that's common sense, right? It's the one way you can get a court to dismiss a case over the objection of a prosecutor, even if there's no legal problems, right? So it's a great tool for certain types of cases. That's why I've got other videos that say it's really important to hire attorneys for thefts and hit and runs in particular, because that's where this is used the most. And you know, it's important to have your insurance company involved in hit and runs so you can get all the damages paid. So if the case is dismissed, what does that mean? That means you were never convicted, right? If you got fingerprinted, there might be an arrest record you need to clear later. But if you weren't fingerprinted, there's going to be nothing on your official criminal history if you get your case dismissed, right? Unofficial sources will show you're in court, but your official criminal history, you can't get better than a dismissal. So I hope you find that useful. Hopefully it gives you some hope and some information. And if you did, please like and please subscribe. More people will get the help they need. And more importantly, if you need some help, if you have a case, if you think we might be a good match for you, feel free to give my office a call. We've been doing this for more than 20 years. We'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.